Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about extradition and racketeering. Cases that should have gone to the Supreme Court of Canada, but didn't. Peter Nygård is famous in Canada and the United States for having recently been convicted of a number of serious criminal offenses. He's also facing extradition to the United States for offenses for racketeering. Racketeering is not a criminal offense in Canada, and generally speaking, there is a rule in extradition proceedings that you're not going to be ordered to be removed from Canada to face trial in another country for charges that wouldn't constitute a crime in Canada. You wouldn't be ordered extradited, for example, to Singapore for chewing gum, even though that would be a criminal offense in Singapore. It's perfectly legal in Canada. And so Mr. Nygård argued against his extradition, stating that because racketeering isn't an offense in Canada, he shouldn't be ordered to stand trial in the United States for those charges and ordered to be sent to the United States for that purpose. The court disagreed, however. Mr. Nygård sought leave to appeal to the Supreme Court of Canada, and that was dismissed. And this does raise an important question, because although the rule is that you can't be sent to another country to face trial for charges that don't exist, there is still a comparative analysis that needs to take place. And while racketeering itself isn't something that is entirely a criminal offense in Canada, committing fraud with your business is a criminal offense in Canada. So to the extent that Mr. Nygård was facing charges that were rooted in the offense of fraud, the courts found that it was reasonable for him to be extradited. But the Supreme Court of Canada should have taken this opportunity nevertheless to hear this appeal, particularly in considering the way that comparative criminal analysis needs to be done and reining in the scope of comparative criminal analysis. If we look no further than our neighbors to the south, who have multiple criminal statutes in multiple states, this could raise significant problems for Canadians who are accused of committing offenses over the border. If only a small amount of comparative relationship is necessary, then people may be extradited where extradition shouldn't have been ordered. The Supreme Court of Canada had the opportunity here to really distill down the specifics of how this type of analysis should be done, particularly when it comes to offenses that are grounded in things that would be offenses in Canada, but aren't necessarily completely the same offense, especially when those offenses often involve special sentencing considerations if a person is convicted of them, like racketeering and RICO offenses do in the United States. It was an important case for the Supreme Court of Canada to consider, not only to clarify this for people in the future, but also to ensure that the more sort of broad assessment of criminal activity that occurs in the United States isn't used to unjustly extradite people in the future. Hopefully, the Supreme Court of Canada takes another opportunity to look at this issue and determines a very clear test for how to determine whether something is substantially similar enough to constitute an offense in Canada. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.